Well, good morning. Good afternoon, I mean, excuse me. It's been
is
a long
it is
day, I
morning.
might add. It's been a long day. We started early this morning. Anyway, good evening. Welcome to our tonight's public hearing. Before we get started, turn off any cell phones or other electronic devices to avoid any interruptions. And if you're planning on presenting any testimony, please sign in the sheet at the back of the room. Anyone who wants an opportunity to speak tonight will have time to do so. Please step up to the podium when it's your turn and make sure you clearly identify yourself for the record before you begin your testimony. We request that you please keep your testimony focused on the relevant issues and facts for each application. Please remember these hearings are to allow for members of the public to speak on issues related to land use applications, not to air grievances about each other or your neighbors. We will not tolerate or allow testimony that is hateful in nature and will stop your testimony if it delves into a statement other than on any other people's character. Okay, it's Wednesday, the 10th day of September. The time is 6 o'clock, the time set for the public hearing. Commissioner Daly and myself are present. Commissioner Davidson is currently absent. Are there any changes to the agenda, Mr. Clerk?
No, sir.
Okay, there's no changes to the agenda, so we'll get right into it. It's our intention at this point in time to skip over the unfinished business and to begin with the new business, which would require a motion. I'll accept a motion to do that.
Mr. Chairman, I move to amend the agenda to move Roman numeral 5 to switch places with Roman numeral 4 and Roman numeral 5 on the agenda. So the two items of new business will be considered before the unfinished business.
Okay. Is there a second to that motion?
Second.
Okay. Well, you've heard the motion. It is to change Roman numeral 4 to Roman numeral
5.
5. Okay. So we'll take up the new business first, and then we'll take up the Roman numeral 4, which is unfinished business. Okay. All in favor of the motion, say aye. Aye?
Aye.
Motion carries. Thank you. So now I'll open the public hearing on application 2022-00185 MSPTE Matrix Construction. We'll ask Brent to give us a report first. Go ahead, Brent.
Mr. Chairman and Commissioners, project number 2022-00185 MSP-TE is a board-level time extension for a master site plan for a multifamily development consisting of 16 apartments. The property is located in the southwest Boise area near the intersection of Lake Hazel and Cloverdale Roads. The property is located at 5971 South Cloverdale Road at the intersection of Cloverdale Road and Gisborne Street. The applicant is requesting a 2-year time extension. The development will consist of fourplex apartment buildings. The applicant has stated in his detailed letter that the time extension is needed due to the current state of the economy, as construction costs have risen due to interest rates, tariffs, and labor costs. The applicant also mentioned in their detailed letter that they hope to start construction by the spring of 2026. This is the applicant's first board-granted time extension. If the board were to approve of the time extension, it could be given until August 10th, 2027. We have not received any written public comments on this application. We have received agency comments from the Ada County Building Official, Boise Public Works Department, and the Ada County Engineer, and none of them have raised any objections to the time extension. Staff finds that the application complies with the Ada County Code and recommends approval to the board, and I'll stand for any questions.
Any questions of our staff? Go ahead.
Just make sure, when this was approved the first time, were there any objections from the community?
There were some objections from the community. We did have some people that did come to the public hearings that would have preferred a different land use at that particular location.
But that's not what we're discussing tonight, though. It's just
That is correct.
extension of his.
It's just the extension of the master site plan so that he'll have an additional 2 years to complete the project.
Thank you.
And they're going to put in fourplexes?
Mr. Chairman, yes, that is correct.
And in that location, is there sewer available to them?
Mr. Chairman, it is. This is a lot within the existing Rockhampton subdivision. So on the screen here, you'll see kind of the single-family homes that are kind of to the west of that. So this particular property is in the same subdivision as those homes to the west. And so along Cloverdale Road, there were a couple of different commercial lots along Cloverdale Road that were part of this overall development. So this was kind of a planning unit development that Tucker Johnson did probably like over 20 years ago. And so, so the residential component of the development was built out, but then there are kind of lots that front Cloverdale Road that have not been built out. And because this was already entitled before the city's sewer policy went into effect, these lots that are part of Rockhampton
They do have an
subdivision.
entitlement then.
Yep.
Okay. All right. Any other questions of our staff from the commission? Okay, hearing none. I have Brian Wilson. You wish to speak? You can if you want. You don't have to.
I'm the landowner, so.
Okay. Well, come up and tell us. Please pass it. That'd be good.
My name's Brian Wilson. I'm at 6171 Cutting Horse Drive in Cuna. And I have owned this property since 2011, I think 2012.
Okay. So you do have the sewer rights.
Yeah, we have sewer, water, everything's there.
And you do think that 2 years is enough for you to get the project complete?
I hope so. I hope that things straighten out a little bit and we can get some prices that are, you know, it's getting so expensive that development costs have just keep skyrocketing, and it looks like things are gonna come back down a little bit, so hopefully they will.
Okay. Any questions, or do you have anything else you want to tell us? Any questions
Not really.
from the commission? All right, thank you.
Thank you.
Thank you. I have another fellow down here, but he says he supports solar, so I don't think that has anything to do with this application. Is that right? It's Aaron Mecklenburg.
Edinburgh.
Yeah.
Yeah, I'll come up later when the time comes.
No, we're not taking any testimony on solar.
Okay.
But anyway, okay. Well, then I will close the, is there, oh, wait a minute. Nobody signed up other than Brian Wilson. So if there's anybody else here that would like to speak on this application, it's a time extension. It's 2-year time, board level time extension. I see nobody here, so okay. Is there any documents you need to add to the record?
Yes, Mr. Chairman. My presentation will be exhibit number 19.
Okay, we've added exhibit number 19 to the record, and no one else here to speak, so I'll close the public hearing on application 2022-00185, MSP TE Matrix Construction. Hearing being closed, the question is, shall we grant a 2-year time extension? Is there any discussion from the board? No discussion, not accept a motion.
Mr. Chair, I'll move to have the board approve application number 202-200-185-MSP-TE, Matrix Construction, Inc., based on the staff report and the testimony heard this evening.
I second the motion.
Okay, you've heard the motion. Any further discussion? Hearing none, all in favor say aye. Aye?
All right.
Motion carries, thank you. Get your time extension. I hope the market fits for you so you can get your project built. Okay, next up, we have, I'll open the public hearing on application 2025-01354-V, Joseph Gunther. We'll ask Brent to give us a report. We'll go from there. Go ahead, Brent.
Mr. Chairman and Commissioners, project number 2025-01354V is a variance for lot size for a property located in the Rural Preservation District. The property is generally located in the West Boise foothills, north of Hill Road and east of Siemens Gulch Road. The property is located at 8560 North Lost Sage Lane and consists of approximately 4.41 acres. The applicant is requesting a variance for the lot size of the parcel. The 4.41 acre parcel is below the minimum lot size of 40 acres for the Rural Preservation District. The applicant is seeking a variance so that the property can be eligible for a building permit. Unless a variance is granted for the property, no structures will be able to be built on the property. The subject property and the surrounding area have a unique history. The property is a part of an illegal subdivision that was created by Joseph and Lillian Barnes. The Barnes were a large landowner in the Boise foothills. In the 1970s, the Barnes started to subdivide their property without getting the proper zoning approvals, resulting in the creation of non-conforming parcels throughout the western Boise foothills that did not meet minimum lot sizes. The subject property was conveyed from Lillian Barnes to Robert Aldridge on May 19, 1979, and became of record on April 30th, 1980, when the deed was recorded in the A County Recorder's Office. Robert and Kim Aldridge later conveyed the property to the current property owner, Joseph Gunther, on September 7th, 2018. When the property became of record in 1980, the property was zoned D1. The D1 zone at that time required a minimum parcel size of 80 acres. Thus, when the property was created, it did not comply with that 80-acre minimum parcel size. Article 8-1B of the A County Code has standards and regulations for non-conforming property use or structures. These regulations apply to properties that were not created in accord with the regulations in the A County zoning ordinance, and that were of record in the A County Recorder's Office prior to January 1st, 1985. A property shall be deemed conforming and shall be eligible for building permits if it meets the dimensional standards for the base district in which it is now located, or a property shall be deemed non-conforming and shall be eligible for building permits if it meets one of the following standards. 1, the property met the dimensional standards for the applicable base district at the time it was created. 2, a dwelling as herein defined was constructed or placed on the property prior to January 1st, 1985, provided in the event that the dwelling is subsequently damaged or destroyed by fire, flood, explosion, wind, earthquake, war, riot, calamity, or other catastrophic event after January 1st, 1985, the property remains eligible for a building permit. The subject property does not meet any of these provisions, therefore is currently unbuildable. In order to grant a variance, 3 findings need to be made. 1, the variance shall not grant a right or special privilege that is not otherwise allowed in the base district. 2, the variance will use an undue hardship due to characteristics of the site. And 3, the variance shall not be detrimental to the public health, safety, and welfare. Staff finds that the variance does not constitute granting of a special right or privilege, as there are several neighboring properties, as you can kind of see on the screen here, that are non-conforming for lot sizes in the area. In addition, the board has granted other variances in the area for lot size, and you can kind of see at the top of the screen here, this is a property that the board back on October 22nd, 2024, had granted a variance for lot size on that property. And that property is only about a quarter of a mile away from the subject property. Staff also finds that the variance relieves an undue hardship due to characteristics of the site. The subject property is on the southeast side of Lost Sage Lane and is separated from the rest of the applicant's properties on the northwest side of Lost Sage Lane. The 4 adjacent properties are under different ownerships as shown on the screen, and thus this property is not able to be put back together due to different property ownership. In addition, staff finds that the variance is not detrimental to the public health, safety, and welfare. Information regarding the variance was transmitted to affected public agencies charged with the protection of the health, safety, and welfare of the public, and none of the agencies or political subdivisions have indicated that the variance would be detrimental to the public health, safety, and welfare. There has been no written comments received from the public on this application. None of the agencies have raised any objections to the application, and staff finds that this application complies with the county code, and I'll stand for any questions.
Any questions from our,
Mr. Chairman?
yeah, go ahead.
My question, if you put the picture back up, so that, I'm assuming the Phelps live in that house. That road is their only access, correct?
Yes, so it appears that is their driveway to their house, yes.
So that road goes through the Kirstein's property as well. The way it's depicted on the map, right?
It looks like it is, yes.
So do they have, and I go, this is third, but do they understand that they're going to either have to get permission from them? What is their standard that they're going to have to meet in terms of getting to their house if they build another house on that site and the access to their house?
Sure. So, Mr. Chairman, Commissioner Daley, so the applicant's property actually has frontage on Lost Sage Lane, which is
Okay.
a public roadway. So, so luckily for the applicant, the subject property that this application is for does have frontage onto Lost Sage Lane. So it does have frontage and access, to a public road that's maintained by the applicant. In terms of the Phelps, it looks, and I'm not really familiar with their particular property. It looks like they have a driveway that comes off of the road and it goes through kind of the subject property. So it looks like, when this, as I mentioned before, the property has kind of a unique history. It looks like when, the property was sold, it looks like the barn just kind of had kind of like a little bit of I think this is kind of would be considered an open driveway to the Phelps property. So it's not owned by the subject, by the applicant, but it's kind of an open driveway that the Phelps use to get to their property.
Okay, I just didn't want to complicate a situation that may be there by doing this, but that's why I was asking you, because I know you've looked at this and discussed it with them.
Yeah, I mean, luckily for Mr. Chairman, Commissioner Daley, luckily for the applicant, it would be a much more complicated if we're trying to get variance on the Phelps property. But with the applicant's property being on Lost Sage, which is an ACHD road that the property owner maintains, that gives him the required frontage and access that he needs for the property.
Thank you.
Any other questions of our staff? Hearing none. Thank you. Is Joe Gunther in? Here. Welcome to our meeting. What's your name and address for the record?
Joe Ginther. I'm at 8571 North Lost Sage Lane. I also own 8560 North Lost Sage Lane. To answer kind of the question that was already kind of posed, in 2011 when we got our private road approval, and we hold a license agreement with ACHD for maintenance that included all of there was a resolution, I think it was 1065 was the number that this board approved, and then ACHD approved the board recommendation, or it was the resolution 1066. So again, that's 14 years ago, so if I'm a little wrong, don't take it out on me. But yes, so the ACHD holds a bunch of property in this valley as public unopened right-of-way that is maintained by Lost Sage Lane Homeowners Association, which is us. So we built the road. That will not change. The Phelpses will still have access through there. Likely, when we've worked with the fire department, they're going to require that property or that road to be brought up to a better standard for care of an all-weather surface for fire access to both the new house and then also the Phelpses, and if the Kirsteins ever decide to build.
Thank you.
This is pretty straightforward. It's the last property I have, so hopefully you won't see me again.
Right, Mr. Chairman, my question was just so that we weren't creating another problem for you, so that.
Correct. Yes, sir.
If we approved it. Thank you.
Okay. Any other questions? Okay. Thank you.
Thank you.
Okay, Brent, do you have any documents needed to be added to the file?
I do, Mr. Chairman. My presentation will be exhibit number 23.
Okay. Okay, well, is there anyone else wishes to testify on this application? Nope. Okay, I will close the public hearing on application 202501354-V. The public hearing being closed. What's the pleasure of the board?
I'm ready for a motion if that's.
I'll accept a motion.
I move that we approve application 202501354-V, Joseph Gunther, the variance of lot size.
Okay, is there,
based on the findings, of fact, and conclusions of law and the discussion we've had tonight.
is there a second to the motion?
I'll second that.
Okay, you've heard the motion. Any further discussion? I don't hear any further discussion, and I think it does fit within our findings, of fact, and conclusions of law as presented. And I'm willing to vote yes. I call for the question. All in favor of the motion signify by saying aye. Aye?
Aye.
Motion carries. Thank you. Okay, we're finished with that section of our business. It appears that most people here, we're here for this planning and zoning thing, because it's a whole comprehensive rewrite. And so we're back to unfinished business, and I would accept a motion to remove the unfinished business from the table.
Mr. Chair, I'll move to remove the unfinished business from the table for consideration.
I second the motion.
Okay, you've heard the motion to remove unfinished business from the table. Any discussion on that motion? Hearing none, all in favor, say aye. Aye?
Aye.
Motion is carried. Now, I might add for the folks that out there, this hearing has been closed. We took all the testimony, and we took quite a bit of testimony. When was it? About a little over a month ago?
July 30th, Mr. Chair.
July 30th. We took a lot of testimony on July 30th, and we had lots of material to digest, and that's one of the reasons that we tabled it till tonight to discuss the issues. And we may get through most of it, but we're going to start going through, because it's a large comprehensive rewrite of our planning and zoning ordinance. So, and we're asked Richard here to, he's inherited the mantle. So, go ahead, Richard.
Multiple hats you have.
Yeah. So, Mr. Chairman, Commissioners, happy to walk through potentially recommendations that have been made for your deliberations tonight. I don't have any new information to present, but if that would be helpful to you.
What would be helpful if you could go through areas, and then if we come to a decision point, if you'd tell us that we need to make a decision on that point.
Sure. So
We can't segment this out into different sections, can't we?
Yeah, Mr. Chairman, I think that's perfectly acceptable. We can bring up topics. You can kind of deliberate and make a decision on individual topics, and we'll kind of take notes and collect those and as
All
we
right.
go along.
Maybe just start with a quick overview for the public and the press of what we're doing tonight.
Yeah, so Mr. Chairman, Commissioners, for the benefit of the public, we started a massive rewrite of our zoning code that's been due for the last quarter of a century, 25 years. We started 5 years ago, gone through quite the process. We have held numerous workshops, public meetings, received thousands of comments, had a lot of drafts to try to keep track of. Appreciate all the feedback we received from the public in the various workshops, the information that they provided to help craft this new ordinance. Essentially, this is an opportunity for us to streamline and simplify some of the standards that we've worked with over quite a few years, where we have had lots of small zoning ordinance amendments to the code the last 25 years. So this is the first major rewrite that we've had in full. So I'm trying to think what other information I could provide, Mr. Chairman, Commissioner Daly.
Okay.
Mr.
Yes, go ahead.
Excuse me, just as a brief comment back to what Richard was just saying. Thank the staff for all the work they've done over a 5-year period, because we really rely on you as well. And then thank to the public. Obviously, the public's here and they're interested in what we're going to be doing here. They've made comments. We appreciate that. Like you said, there were thousands of comments that were made. We've looked through those and digested them, or tried to. And then the third thing is our Planning and Zoning Commission, which they did extensive work on this as well, so thank them as well. So this is the process that our founders gave us, is public dialogue, trying to create good policy. We have an obligation under our Constitution as well as under the law, which requires us to do planning and zoning at the local level. So we're required to do that, but also take into consideration private property as we do that. So those are kind of our basic parameters, and we appreciate you walking us through what you've done, and so we can review what we viewed as well.
Mr. Chair?
Yes, go ahead.
Yeah, I'll just make a comment. kind of regarding the overview, this obviously is a long time coming, this rewrite. And again, it's a total rewrite of the development code, and so that could include 1,000 different issues, if you broke it down. Unfortunately, or fortunately, however you look at it, maybe 2 or 3 of those issues got 99% of the public interest. And so those issues obviously have been really covered by the public. I'm concerned that the 99% of issues that the public didn't really show up on, people will come back after and go, well, I can't believe you made that change. Now, I don't think that would be justified because we gave this a lot of time, a lot of consideration. What was the first day you think we started on this?
Yeah, Mr. Chairman, that would have been back in 2020. Actually, before 2020 and 2019, before COVID began, we had hired a consultant to start the process, and then COVID hit, and we continued to move forward electronically as best as we could.
And so we've had multiple neighborhood meetings or forums, public meetings, public testimony. Obviously, in this day and age, it is hard to get the word out to people about big changes that are coming up. So I think some people on the 99% of issues that we didn't debate or get a lot of public attention will say, you sprung this on us, even though we've been putting out the word for about 5 years now. Of course, these are ordinances, and even after we pass this, everything's subject to amendment. But I just want to put out there that I think your department and this board and previous boards have not sprung anything on anyone. We've given this a lot of time and a lot of requests for public input. And even when we put it out, we don't always get a lot of public input, but I think we did our due diligence to get the word out about this. So thank you for all the work leading up to this point.
Thank you, Mr. Chairman.
Well, I just wanted to like to add to that we even hired a professional consulting firm to help us with this, did we not?
That's correct, Mr. Chairman.
And that was quite an extensive effort from that consulting firm, and that went on for, a year and a half, something like that?
Yeah, about a year and a half, Mr. Chairman.
Yeah, about a year and a half, and then we started having public input. We had we had one right here in this room, a community engagement where people could come and give us their ideas, and then later we went out in the community and had some community engagements, and we got a lot of people interested in that. In fact, we have a lot of people that have filed reports and filed their recommendations. So this has undergone an immense public scrutiny. So we're glad for that. So go ahead.
Just to reiterate again, these are important decisions, and we have considered a lot of issues, and there are very fine-tuned needles that we have to thread here in terms of private property as well as the other things, but we're going to do the best we can to make that happen so that it is important for the law itself, which requires us to do it, as well as impacts the people and impacts them positively, not negatively.
Go ahead.
Okay, Mr. Chairman, I don't have any, again, the record's closed. I don't have any new information to present. I am going to pull up the staff report that was presented at the July 30th public hearing. It contains a list of recommendations that I think it will be helpful for you to walk through to make some decisions. I guess the question is, do you want to take up the big question first on location of solar farms in Ada County, or do you want to set that aside for last?
Well, I think we should. I noticed you skipped over the chapters because I'd like to add one section to that chapter section.
Okay,
Yeah,
let me get up my.
I'm interested.
Notepad?
I'm interested in that, where we have the chapters of our zoning code. Chapter 2.
Chapter 2. Let me see if I can scroll down real quick to Chapter 2. There
we go.
Chapter 2, zoning districts.
Yeah, Chapter 2 zoning districts. I'd like to add one 8-2-31 and call it the 10-mile planning area overlay district. Is there Discussion on that?
Mr. Chairman, I don't know, we might want to have, does the staff know what we're talking about here?
Yeah, Mr. Chairman, Commissioner Daly, there was, in the list, there was a request or a recommendation from, I believe it was the Brighton Corporation to add this topic to the zoning ordinance. So we are aware of the request.
So, I mean,
Do you have any of the pictures that you can show where it is? and so
right,
forth?
that's what I was just going to ask. If you could walk, if you have anything that you kind of walk everybody through, especially the public that's here.
Let me see if I can find the comments from Brighton Corp, if they were attached here.
Well, they have pictures and stuff if you, pictures of what the 10-mile overlay area is.
Perhaps, Mr. Chairman, if you want to set this one kind of aside for a moment, we can have individuals take a look and see if we can bring that
All right, we can do
information up for you.
that. Okay, let's go on then.
Okay.
I have a couple of them as well, but I think as you walk through, we'll get to them, so.
All right, so Mr. Chairman, I'll just start. I'll walk down. First, I guess before we get into the individual recommendations, I will remind you that Mr. Letson pointed out in his presentation in the staff report that in addition to all these recommendations that you're going to make that we include in the final document, we do have a growing collection of Scrivener-type errors and omissions that we're collecting that will be included, misspellings, definitions that were excluded, sections of or amendments related to state law changes for area of impacts, things of those natures that don't necessarily modify or change what is proposed, but they're just clarifications and things that were missed over the many drafts that we've had. So we'll have that collection that will be included.
So should the board make a motion to authorize authorize your department to make those corrections?
Yeah, Mr. Chairman, I don't know if that's necessary at this point, since they are just the Scrivener-type errors that will just clarifications and corrections. It does not, again, doesn't change the substance of what you're proposing.
Okay,
And that's just normal allowance.
Yeah.
The staff's allowed to do that normally, correct?
Correct, Mr. Chairman. All right, so starting with the recommendations on the screen, let me see if I can make it any bigger. So the Planning and Zoning Commission made the recommendation to remove multifamily housing as an allowed use in the commercial districts. And when it's allowed use, that's a conditional use. I think I could scroll up to the use table here and show you kind of what we're talking about. So the multifamily land use, staff had originally proposed that it be conditionally allowed in our commercial districts, and the Planning and Zoning Commission is recommending, and staff supports this recommendation as well after getting feedback from the public, recommending removing those as conditional uses in the commercial districts.
Sure.
yes, go ahead.
Richard, could you just give sort of a layman's view of what multi-family housing is, what that consists of?
Yeah, Mr. Chairman, Commissioner Davidson, this would be typically 3 or more dwelling units that are attached. You have your typical fourplexes that we saw earlier tonight for the time extension. It's that type of higher density housing projects.
Could you give the staffs and maybe also P&Z's reasons why that would, for that recommendation?
Yeah, Mr. Chairman, Commissioner Davidson, initially staff, recognizing that there is definitely some housing challenges in our valley, and it's been somewhat limiting what we can do as a county to help address that issue. We had anticipated trying to include some housing in mixed-use projects in some of the commercial zones. You'd seen some projects where developers have tried to bring commercial and residential together, and so it was There was a recommendation, I even think, from our professional consultant to include that as a conditional use. It would still require a public hearing, but after receiving feedback, we held some additional open houses, decided to go ahead and support that recommendation of removing that for now. Somebody could still propose residential housing, they would just have to go through some type of rezone.
Well, Richard, is that what happened out there on that 11-acre parcel that was zoned commercial and a developer wanted to put residential in there with a mix of commercial?
Mr. Chairman, that's exactly an example that may have been an inspiration for this recommendation.
But in that case, it was all zoned commercial, and they were asking for a rezone, isn't that what?
That's correct.
Yeah, and so they could still do that under what we're talking about here.
Yep.
Yeah, okay. Okay?
Mr. Chair?
Yeah, go ahead.
So, Richard, I guess, the concern would be, would this kind of stifle, innovative projects where somebody wants to do the mixed use, retail business on the ground floor, apartments, condos on the top floor? Are we, does this limit, and we've been presented with those before, but they didn't pan out because we felt it was not enough commercial in the mixed use, but is this kind of maybe hamstringing these types of projects in the future?
Yeah, Mr. Chairman, Commissioner Davis, it's hard to say. I think it may make it slightly more difficult, but as the chairman said, we've seen an example of a project under the existing code with the mix of uses through a rezone and other application types that are available. So it doesn't shut the door entirely, but it may make it a little bit more challenging.
Mr. Chairman.
Okay, go ahead.
Just to reiterate what you just said, so it doesn't close the door totally, but it makes it, there are hoops that need to be jumped through that would be required additional.
That's correct, Mr. Chairman, Commissioner Daly.
So if a project came along that was zoned commercial and they wanted to put some residential in it, they'd have to request a rezone.
That's correct, Mr. Chairman.
Okay. All right. Do you need a motion on that?
That's what I was just going to ask, individual motions on these as we go through them, do you want?
I think we probably should move on each one, and it would be a motion to add it to the overall, not adopting it, and then we would adopt at the end.
I'm not sure you really need to make a motion, you just need to direct
Staff to
your
do.
staff to make a note. You basically are going to agree with removing it as an allowed use in those zones, correct?
Yeah, because we're going to have to table this anyway, because to get all this stuff done, and then we'll consider, yeah.
So this would be just directive to the, Mr. Chairman, just be directive to the staff to do it in our final version, which you're going to bring back to us.
Exactly.
All right.
I guess my only concern with that is if it's not a unanimous decision on any one of these items.
Well, if you wanna, if you realize you're not gonna be, then you can take a vote. I don't know how you feel on this one. If you feel like you're all in agreement with this one, we can move on. If you wanna take a vote, you can do it for each one.
Well,
Mr. Chairman, I'm in agreement with.
I'm in agreement with it. Are you opposed? Do you want to vote no?
No, I'm in agreement.
Okay, move on.
I'm just saying there are obviously many other ones.
There may
Very
be
well
some.
could be, you're right.
Okay. Thank you, Mr. Chairman, Commissioners. Next up, I may take these next two together. I think it may be helpful to, again, look at this specific, or the allowed use table here. So the Planning and Zoning Commission, again, has a recommendation that you remove the, I guess, the land use of a duplex from the rural residential, rural preservation, RUT, RSW, R1, and R2 districts. So a duplex is 2 dwelling units on one property. Currently, the duplex is combined with a detached, or I should say a single-family attached dwelling, which is a townhouse, which is 2 dwelling units separated by a property line under separate ownership. So they're recommending that this not be a permitted or allowed use in basically everything under the R4 zone, if I've got that correct. Correct, yeah, so it would be an allowed use in the R4, 6, 8, 12, and 20 zones, but not in any of the other zones. And they're also recommending that the townhomes not be allowed in the R2 zone. So those are the next two recommendations for your consideration.
Okay, I think that's a little overboard myself. I mean,
Chair?
yes.
Just wondering, as you go through these, Richard, do you want to say what staff's position is versus P and Z, or?
Yeah, Mr. Chairman, or Mr. Chairman, Chris Daly, happy to provide whatever information you may feel can help you in your deliberations. Yeah, in this case, similar to the previous topic, again, with housing challenges in the valley, opening up a few more zones to duplexes, which haven't traditionally been a very, popular dwelling type that we've seen a lot of. Opening that up into other zones, we thought was potentially an opportunity to increase housing opportunities.
Well, I think it probably would, particularly with a townhouse kind of a thing, which is becoming increasingly popular in this valley. And we certainly need room for more housing. So I think personally, I'd like the staff's recommendation.
Mr. Chairman, I guess this would, if we removed it like the planning and zoning recommended, we would be doing the same thing we did before, just making it more difficult for them to do it, not impossible for them to do it. That's a question.
Yeah, so Mr. Chairman and Commissioner Daly, excellent question. In this case, it would prohibit a duplex in those zones. There would be no option unless they wanted to try to rezone property to a higher zoning designation like the R4 zone or up.
So they would have to actually go to they could do it, but it would be more complicated than the
Much more
previous.
complicated, especially in the rural preservation and rural residential districts that really aren't eligible for rezones to higher densities. Yeah, it would really kind of shut the door there.
Mr. Chair?
Yeah.
Richard, what are the lot sizes under these zoning designations?
Is an excellent question. I don't know if they changed. The rural preservation and rural residential are 40s and 10s. The RUT zone is typically a 5-acre zone. RSW is 2.5. I'm just kind of quoting the old code. So,
It's the same.
oh, it's the same. Okay, so R1 is 1 acre. R2 is 40,000 square feet. So you've got 40,000 square feet all the way up to 40 acres.
So these are the larger lot sizes, and I'm assuming this position kind of came about thinking of like the character of neighborhoods, where you want a neighborhood that's all single family on large lots?
Yeah, Mr. Chairman, Commissioner Davidson, I'm not familiar with the kind of the counter argument as why the Planning and Zoning Commission thought that this would not be the best idea. I apologize, I don't have that information.
Well, and that would be a market condition depending on what the owners wanted to put in their project. It wouldn't be something but well, again, we can keep batting it around, but I'd like to go with the staff's recommendation.
Mr. Chairman, I guess I'm inclined to support the planning and zoning's recommendation myself, but so that's my position.
Looks like you might need to make a motion on this one, see which way you want to go.
It's up to Commissioner Davidson then.
Maybe we can take them up. There were 2 recommendations. Let me back up here. Maybe you can take them up individually here. So the first one is to remove duplexes as an allowed use in RP, RR, RUT, RSW, R1, and R2 districts.
So I guess I have another question. But
Go ahead.
what is the extent of, because that looks like a long list, but what is the extent of the properties that this would apply to in the county? Do you know just how much property this would apply to?
Mr. Chairman, Commissioner Daly, I don't know the exact, I don't have those details. We have a lot of rural residential and rural preservation property in the county. That's everything outside of areas of impact.
Well, and knowing that this requires before anyone could do anything in this area anyway, they'd have to have all the public services, correct?
They'd have to have, Mr. Chairman, enough public services, at least for a single-family dwelling, So septic system, power, those basics, frontage.
Right, well, anyway,
Mr. Chair?
yes.
So I guess we're probably going to be talking about accessory dwellings at some point, but what would the new code say about accessory dwellings? You know, if we didn't have duplexes, what would be allowed for accessory dwellings?
So the accessory dwelling code, Mr. Chairman, Commissioner Davidson, is already existing. It was approved in 2024, early 2024. So it allows somebody to apply for attached or detached secondary dwelling as long as they have a primary dwelling. So that is still something that exists in the code as well. That's not necessarily a duplex, but it's similar. Duplex would have the advantage of not having the size limitations attached to the units, to my knowledge.
And on the accessory dwelling rules, is it supposed to be owner occupied, so like owner's family, or do the rules allow, another party to rent that out?
Mr. Chairman, Commissioner Davidson, yeah, the way the code is currently reads is that the owner needs to occupy one of the units, the primary dwelling or the secondary dwelling.
But the owner is allowed to move in anyone to the accessory dwelling unit he wants.
That's correct.
So I guess in reality, what's the difference between a house with an accessory dwelling unit versus a duplex?
Yeah, Mr. Chairman, Commissioner Davis, it's really a product type in my mind. Again, the duplex, to my knowledge, doesn't have the size limitation that the secondary dwelling would have. So that would be one advantage. And then the duplex wouldn't have the occupancy requirement. Be another difference to consider.
What about the townhouse thing?
Yeah, Mr. Chairman, townhouses, you have basically two separately owned units that just happen to have a shared wall.
But the planning and zoning recommendation is to eliminate townhouses in the rural preservation district as well, correct?
So if I go back up, Mr. Chairman, to that use table, the townhouses, since they were separated from duplexes in this proposed code, just pass it there, they are just the only new zone, if you will, that they're proposed to be allowed in this newer version of the code is the R2 zone. And the Planning and Zoning Commission is recommending that you not allow them in the R2 zone, that they would remain allowed in the R4, 6, 8, 12, and 20 zones,
But not the R2 zone,
but not the R2 zone.
which is a little, I think it's a little difficult because the R2 zone is for single-family homes anyway, aren't they?
Yeah, they are, Mr. Chairman.
And townhouses are single-family homes.
Townhouses are single-family homes.
So I don't get that. But that's the planning and zoning recommendations, that's not staff recommendations.
That's the
correct?
Planning and Zoning Commission's recommendation is on townhomes, is just to remove them from the R2 zone. So
But
that's a
that's not-
separate
But that's
recommendation.
not staff recommendations.
It's not a staff
Okay.
recommendation.
Well, I don't understand why we'd want to do that when it's single family anyway. And it's not, well, anyway, go
I'm
ahead.
just trying to put myself trying to envision what an existing neighborhood would object to or would consider out of character with their neighborhood. And I don't know if you'd prefer to have a duplex move in versus a single home with a detached accessory structure. And I don't know if we need to debate that to death, but I don't know. I think I could go either way, but it seems like if you eliminate duplexes, you encourage accessory uses. So I don't, kind of splitting hairs, it feels like a little bit.
Well, you're eliminating accessory uses except because the accessory has limitations on it. That's the difference. The accessory use has limitation, a duplex would not.
Excuse me.
Would be, and the accessory uses, you'd have to have owner occupied in one of them, and you wouldn't have in a duplex necessarily. You could still have an owner occupied duplex, and I would think you're starting to see a lot of more of those anyway, an owner occupied duplex. And I don't think we have a lot of area that would fit this category anyway, in my view.
Mr. Chairman, I think from my opinion, it goes to the character and style of the entity itself. A duplex is totally different than a single-family home and an auxiliary dwelling. The nature of the use may be similar, as Commissioner Davison said, but the style and, again, fitting into the community would be totally different than a single-family home and an auxiliary
Well,
dwelling.
except townhouses are single family.
I understand that, but it's the style of And we control some of that anyway in terms of, our associations do, the kind of houses that are built. So anyway, that's my opinion. That's why I'm where I am in
All
terms
right,
of,
well,
so I guess we need to vote.
we need to vote. I'd go along with staff's recommendations, so it's up to Commissioner Davidson.
So just so I'm clear, so are we starting with the duplex?
I would consider both of them together,
They're
but
both together.
they're the two of those two
Because the
recommendations.
planning and zoning had a different recommendation than the staff, and I'm supporting the staff recommendation. And Commissioner Daley is supporting the Planning and Zoning Commission's recommendation. We don't know what Commissioner Davidson's doing. He's the decider.
I'll support the staff recommendation.
There you go.
So, Mr. Chairman, Commissioners, I'm hearing you're not following the recommendation of the Planning and Zoning Commission to remove these uses.
On those two,
On those
last two items.
Two items.
Well, you remember what the staff recommendation was, don't you?
Yeah, Mr. Chairman?
That's it.
And so, existing neighborhoods with HOAs, they're able to regulate that they wouldn't want those, is that?
Well, right. And
Correct.
plus the developer of the property, if he doesn't want those, they wouldn't put them in there.
Well, not necessarily.
No, it
If
depends.
the homeowners association isn't law,
They're not law. A law is not.
they cannot prohibit a builder from doing something in that context.
Right, but anyway. Okay, moving on.
Okay, Mr. Chairman, Commissioners, up next are the solar facility recommendations. Do you want to move into those, or do you want to skip past and get all the other low-hanging fruit first?
Well, let's get the low-hanging fruit.
Okay.
Do we have very many of those conflicts between the planning and zoning and the staff recommendations?
Any more?
Yeah.
I can't think of any, Mr.
All right,
Chair.
let's go ahead
I
and
guess
go
we'll
through-
discover. We'll discover them together.
All right.
All right, so up next, the Planning and Zoning Commission specifically recommends that you reestablish an existing section of our old code and add that to the new code. It's the preservation of property rights or private property rights as shown on the screen. This particular language they'd like to see added back into or reestablished into the code. As Mr. Letson explained in his report in July, these elements are incorporated throughout the new ordinance, but the Planning and Zoning Commission would like to see this exact wording added, and staff doesn't have any particular concerns with adding this back into the code.
So this is sort of a redundancy?
Yeah, Mr. Chairman, in some ways, yes, but it puts all the information there right together. We would probably place it right at the beginning of the new code.
Mr. Chairman?
Yeah.
That's one of the themes that we heard a lot about, is private property rights.
Oh, yeah.
And it's, again, in the Constitution as well as in the Planning and Zoning Ordinance. State Planning and Zoning Ordinance is protection of private property rights. So I think even though it may be a little bit redundant, this would put it all in one place, very clear
fine.
as to what our stance is on private property rights. So I would agree with the Planning and Zoning.
And I've read through this, and I don't see any objections to the.
No, there's no
to the-
objection. It's, as you said, some of it is restatement of.
It's a redundancy, but,
Mr. Chair?
yeah.
So in item B, which is talking about no employee of the county shall enter upon, investigate, or search any of the premises of any citizen without the consent of such citizen or order issued by a court of proper jurisdiction. I fully agree with that, but I'm just wondering, does that come up across any other code? Because we obviously have code enforcement officers who, they don't enter the premises, but they do enter upon what would you call it, the open areas, like the front yards, to investigate complaints. I mean, is there any conflict between those two?
Yeah, Mr. Chairman, Commissioner Davison, I would not be able to respond. I don't know what the procedure is for our code enforcement officers. I know that we won't enter upon somebody's property unless we have their permission. So throughout the zoning code, I think we're fine with this language. It's the existing language that we work with today.
Okay, well,
Mr. Chairman?
yeah.
I think even the assessor can't go on the property without
No,
permission.
without the owner's permission, yeah. Okay,
I guess the word premises would probably be defined as the actual house or inside of a a structure. But I support the language.
Okay, I'm
I don't hear
hearing,
any objection.
I'm hearing that you want to follow their recommendation.
Sure,
Okay.
we'll take the Planning and Zoning Commission's recommendation.
Okay.
They're advisory, and we'll take their advice on that issue.
Okay, the next recommendation from our Planning and Zoning Commission is for the board to consider additional standards for commercial towers and antenna structures. So this is a recommendation for cell towers. And the staff response in this case is based on, I believe, your direction. We're already pursuing with interested parties a rewrite of the standards for cell towers, separate from this effort. Given our expectation, there's going to be a lot of interest in that ordinance. We're undertaking that separately. So we would, as staff, would not recommend trying to add that to this ordinance at this time.
Okay, which one's that on?
That's right here under these. It's right, the next one.
It's on the screen. Oh, right there. All right.
So, Mr. Chairman?
Yes.
Yeah, that was my question to you as well. We are already in the process of reviewing that extensively, and we will have public hearings on it, et cetera, outside of this. And I would take staff's recommendation on that one as well, since we're already doing it.
Well, let's give a unanimous support of staff's recommendation.
On this one, yes?
Yeah.
Yes.
All right, thank you, Mr. Chairman, Commissioners. All right, next on the screen, the commission recommends considering a new process for inspecting required landscaping improvements at the time of installation to ensure long-term viability. And,
What does staff say about that one?
Mr. Chairman, this one is
Be the one doing doing the inspections.
yeah. So, Mr. Chairman, this one would be a challenge for staff to inspect every single planting to make sure it was done properly. I would be concerned about our ability to do that. Right now, we're able to verify that the landscaping is installed, but as far as verifying if it was installed correctly or if there are any issues with the plantings, that would be a challenge for staff. But this is a recommendation from the commission based on feedback from the public testimony that they considered.
Well, this would include parks in the county jurisdiction, would it not?
This would essentially apply to anything that's
You know how many
related to
thousand
something that
plants
we
we're gonna be
approve.
we're going to be planting out at the park at Expo?
Hundreds.
Thousands. I don't think you want to go out and inspect all those, do you?
I don't think you want me to, Mr. Chairman.
Well, obviously, you could expressly limit it to development projects that don't include parks. I guess the question is, have we run into issues in the past where we approved a landscaping plan and then a year later, all their plants die and they just pull them out and basically they are going against the original intent of the conditional approval? Do people call the county and complain and say you need to investigate that they're violating their conditions?
Yeah, Mr. Chairman, Commissioner Davison, this came about from testimony from a member of the public, I believe it was Carol Vidalis in the Southwest, and that was exactly the point, is she said that, after the developer's long gone and the homeowners association is trying to take care of trees, they're dying because they weren't installed correctly, she was hoping for some additional oversight at the very beginning to make sure it's done correctly at the beginning. So definitely some logic to the suggestion, but
So how would
Definitely
how would
logistical
we
challenge.
inspect to make sure that, I mean, other than visually seeing that they planted trees where they agreed to plant trees, what more could be done?
yeah, Mr. Chairman, I think we would have to seek some kind of advice or education on proper plantings of trees and other landscaping. So it's a very heavy lift for our staff.
Mr. Chairman?
Wouldn't that require some increased staffing? And more
Potentially, Mr.
expense-
Chairman.
More expense to the application, correct?
That's correct, Mr. Chairman.
Yes.
That's where I was going as well, is that they don't have the expertise, and I've planted some trees, and so you have to almost be standing there when they plant the tree to know, just because you go out there and inspect it, it's planted, doesn't mean they took the root ball off, as an example, or there are any number of things that could have been done. So it's the extent of requirement for the staff involvement / understanding and education is kind of mind-boggling, actually.
Chair.
I understand the impetus of the recommendation from public for the need, but
Yes, go ahead.
So currently, does staff give just a visual inspection that they complied with the landscaping plan?
That's correct, Mr. Chairman. Before the project's officially signed off, the staff would take the landscaping plan that's been approved. They'd go out and inspect and verify that the plantings are at least installed and alive at the time of installation.
And we're already doing that.
That's correct.
I don't think I'd want to go further than that. Again,
So-
neighbors could call and complain a year later if all the landscaping has been removed, I suppose.
So then the question is for us is, do we take the staff recommendation because the staff didn't recommend this, correct?
That's correct. This is a Planning and Zoning Commission recommendation.
Well,
again, follow the staff recommendation.
I'm anybody not in favor of the staff recommendation?
I'm not in favor of it.
Of the staff recommendation?
I'll go with the staff
Well, that's
recommendation.
what I mean. That's what this was. Okay, so you've got that. We're taking the staff recommendation on this one. On that
Okay.
one. Okay.
Okay, these next three are recommendations that Mr. Letson covered last time. The very first one is staff in this case. And I guess this one I should back up. I believe the Planning and Zoning Commission supports the same concept. But staff is recommending the removal of new provisions that were added to the zoning ordinance amendment related to landscape watering time restrictions.
Okay. Well, I think we should go along with staff and their planning and zoning commission recommendations.
And I think even my take on the public comment, the public even has kind of gotten there as well in terms of what's required and what, et cetera. So I think the public even has gotten there, because initially they wanted this, but I think they've backtracked from that as well, at least some of the comments that I read and heard. So I would say go along with the staff recommendation and planning and zoning's on removing this.
Yeah, I really see this as kind of a California-style overreach on property rights, so I would support removing it.
Okay, I think I heard agreeance in removing those standards.
Yep.
All right. The next recommendation from staff is removal of language contained in the Southwest Planning Area overlay, essentially stating that if someone's septic system fails, they need to connect to the Boise City sewer system. As Mr. Letson explained again, this is something that we're going to leave to Central District Health to address and recognize it's very difficult to require someone to connect to the city sewer system. So we recommend removing this long-standing standard that's been in our code for quite some time.
So we would be removing Mr. Chairman?
Yeah, go ahead.
We would be removing what would be the impact of this?
So, Mr. Chairman, essentially, Commissioner Daly, essentially, if someone's septic system fails, the code essentially says they need to go connect to Boise City Sewer. They can't rebuild a septic system even if Central District Health would allow them to.
That's currently what it
That's
is.
the current requirement. I don't know the longstanding history as to why that's the requirement. So removing that would enable a property owner to explore all their options. They could go to Central District Health and see if a new system's a possibility before having to try to approach Boise City. And again, this is in the Southwest Planning Area, so Southwest Boise.
Right. We know the area. Okay.
Okay?
I don't think I have an objection to that.
I don't either.
Nope, we're good.
This allows maximum flexibility to the homeowner. And City of Boise is still where they are on that issue, so unfortunately.
Okay, next up, Mr. Chairman, Commissioners, the last one there, the developers of Spring Rock Plant Community identified several clarifying changes in the new code that would pertain to the zoning provisions specific to the Spring Rock development that they propose, and we recommend approval of their proposed changes.
Mr. Chairman? So these are recommendations from the developers of Spring Rock,
Mr.
correct?
Chairman, Commissioner Daly, that is correct.
And those, the Planning and Zoning Commission as well as staff?
Yeah, Mr. Chairman, Commissioner Daly, the Planning and Zoning Commission, I don't recall commenting on this particular request. This has just been a staff recommendation that staff made, recommended to them as well as is now making to you.
Okay.
Will these changes involve changing to the planned unit development portion of our zoning code?
Mr. Chairman, I don't know if I follow.
Well, we have a separate code that does a planned unit development, right?
That's correct.
And Spring Rock made their application under that portion, correct?
That's correct.
So would this change any of that?
Yeah, Mr. Chairman, I would have to dive into the details. My understanding is that there's other references throughout the rest of our zoning code that reference either the Spring Rock specific use standards or vice versa. And the recommendations better help the code align and make it clearer.
Okay. All right.
Mr. Chairman?
Yeah.
So that's how staff came up with the ideas, just to align the processes for Spring Rock.
That's correct, Mr. Chairman, Commissioner Daly.
So I would support staff recommendation.
Yep, I would too. Okay.
Mr. Chairman, I have a couple of questions that I
Go
haven't
ahead.
asked yet. Under where the county engineer, it delineates the county engineer's responsibility, I think it's in 896. I don't know if you can go to that, but it delineates a bunch of things for the county engineer, but it doesn't, I'd like to have something in there about water as his response, as his overall review process. Because there's like 10 items or something like that.
Well, Mr. Chairman, rather than struggle to get there, happy to add a responsibility
Yeah,
in
something.
any language that you would like to see.
No, I'd like to talk about it with him as well, because I don't want to put language in there that is unworkable for him and staff. But I think we need to delineate that is part of his bailiwick. In other words, we're telling him so that when he does it, it's a directive in nature, that he's not just picking it out of the air.
Mr. Chairman, Commissioners, is that,
Could you restate that request?
That part of the county engineer's responsibilities, because of the delineation of his responsibilities, and in that delineation, I'd like to have some water responsibility there, that he has the ability to review water as well, in terms of his recommendations regarding projects.
I could make a suggestion. I think the two ways you could handle this, you want to, going through all these other recommendations, table. You're going to have to table this anyway to get all these changes made. You could table it long enough that you could make these changes and come back and deliberate what you want the engineer to do, or we could bring it forward on a separate amendment to the zoning code a month or two down the road.
However is the easiest for staff. That's
yeah, Mr. Chairman, Commissioner Daly, if we have language that we can plug in, that'll be the easiest. Difficult to do that right now.
right, yes. 'Cause-
Yes, well, so we can include that in the tabling, and then if you can come up with the language in a timely manner to include it in this, we can go ahead and do that. If not, then you can do it in a change to the.
Bring it back
yeah.
for the deliberation.
As we bring it back, then we would discuss it when we
Okay.
bring it back.
So you're not asking for more power for the county engineer, you're just clarifying the existing power.
Right. Clarifying so that he has clear responsibilities if he goes there.
Clear and convincing responsibilities.
Correct.
Okay,
And one more, where we have the Boise Air Terminal, it's in 82255. It has some criteria for weed control, but all of those are basically just delineated based on fire. In other words, they need to be green, et cetera. We've had some situations where people have noted even on the airport authority, that some of the property has these huge weeds. They're green, and they're not fire yet, but they will die and they will be fire hazards. So the county's responsibility under state law is to have weed control, noxious weed control. So I'd like to have something in there that delineates that, not just fire protection on the airport, but other things that we cooperate with them on. We're not mandating to them, but we cooperate develop a process for cooperating with them on weed control on airport property.
And Mr. Chairman, Commissioner Daly, would you be willing to share your reference again? 8.2.
8.2.25.5, I think is what I wrote down, but I might have written it down wrong, but. Let's see, I think I have it in my book here.
8.2.24 in the airport influence area?
Yeah, that's it. So I must have written it down wrong. It's 24, not 25.
Okay.
Anyway, we can do the same thing with that one that we do with the water one. Get with you and then get back, and when it's in the final draft, we can discuss it with all of us so that we can discuss it when we adopt the final draft.
So, Mr. Chairman, Commissioners, I will add that similar to the county engineer responsibility for water. Okay.
Mr. Chair?
Yeah.
I had an idea for a amendment as well regarding approval of shooting ranges, which came up recently. I discussed this with Richard, but it was referring to, I believe it's in our code that says you need to get written permission from the ATF to approve shooting ranges in Ada County. And so I was curious about deleting that one, because if it's not required by federal law to get approval by the ATF, I would not want to continue to impose that.
Yeah, Mr. Chairman, I was going to see if I can pull it up here real quick, but that particular standard we have left in place in the proposal just because it could be applicable. You know, if somebody is manufacturing or storing ammunition or making firearms on the shooting range property, then the ATF would come in. You know, in a recent example, they weren't doing that, so the ATF requirement wasn't applicable. So there's still potentially a need for that standard, which is why it's still there.
Well, I mean, could it be severed so that it applies to shooting ranges that are manufacturing arms as opposed to ones that aren't?
Yeah, Mr. Chairman, Commissioner Davison, let me see if I can scroll up to shooting range. Sorry, this 1,400 pages is. There we go. I keep passing it. There we go. So, yeah, so shooting range, if the board wanted to reword that so it talks about the standards that would kind of trigger the requirement, you could direct us to do that. If that was your recommendation, we could certainly take a look at that. So it's not just a blanket requirement for all ranges.
Because I'm thinking if it's somebody just wants to do a simple outdoor shooting range, obviously getting any permission from the federal government takes a long time, as we've learned. So to me, that seems like an unnecessary requirement if all you're doing is a simple outdoor shooting range.
Well, and this doesn't say if it's required, this just says flat out that it has to have an approval from the Federal Bureau of Alcohol, ATF. It doesn't say maybe approval, it says approval.
That's correct, Mr. Chairman. Yep. Written approval is required.
But then you just said, well, it's not required if they're not doing something that is regulated by the ATF, like making or manufacturing firearms.
That's correct. Yeah, Mr. Chairman. So it
maybe
sounds
we
like
need-
there
maybe we
is
need to clarify
potential to
that.
clarify. Yeah.
Yeah,
Not just as a blanket, everybody does it, but.
all right.
Yeah.
Well, I'd agree with putting that in there to clarify that.
Yeah.
Okay. So I'm hearing clarify when this standard is applicable.
Right.
Yeah, clarify that, I mean, if you're not gonna be making arms or making ammunition or making arms, you don't need to go talk to the ATF
and get written approval.
and get written approval, yeah.
Yeah, Mr. Chairman, Commissioners, we can add an if clause if
Yeah.
the shooting range will include such and such activities, secure written approval.
What you're saying is a requirement of the ATF anyway. Right.
Correct.
So, but it's okay if we have it in our code,
Under those
under those
circumstances.
circumstances.
So it's clear to put somebody reading our code that they don't just automatically have to go get,
So if they read the code and say, well, we're not gonna make firearms, we're not gonna manufacture, ammunition, they don't have to mess with that.
Sounds like a good recommendation.
Okay?
So, Mr. Chairman, Commissioners, before moving into solar, we can back up to the topic of the 10 Mile Creek planning area. Let me see if I can pull up successfully the imagery that you were after before. So here's the Brighton Corporation correspondence. And let me know what you'd like to.
Well, that's the planning area right there.
right.
10 Mile Creek planning area.
And then again, Mr. Chairman, your recommendation was to include a new overlay and a new planning area overlay in the second chapter of the code
Yes,
for this 10 Mile Creek planning area.
make that A8231. And then we can develop over the, before we get this, come to final approval, we would develop the purpose and the applicability and the process and the standards.
So I'm hearing add this section and develop the standards that would apply.
Right,
Mr. Chairman,
yeah,
like we have for the others,
yeah.
like we have for all the others, that would.
Okay.
Just add it and do what we've done with all the others. I would agree with that. I would vote.
Okay, how about you? Do you agree with it?
I agree.
There you go.
Mr. Chairman, Commissioners, that brings us, to my knowledge, back to the topic of solar facilities. I think it may make the most sense to address location to start out, which could influence your other decisions on some of these recommendations from the Planning and Zoning Commission.
In other words, just go through it as it's listed on, you have it listed here.
Yeah, Mr. Chairman, I think, let me jump to the original, I want to say there's a slide here on Mr. Letson's. So, Mr. Letson provided the current proposal in the zoning code as far as solar facilities go, that the one that has gotten the most attention, I would say, is number 2. Solar facilities shall not be located on irrigated prime farmland. And then that's what's in the code. The current code doesn't have this. I should say the old code. The code that we're currently operating doesn't have this particular, I guess, restriction based on a land use characteristic. The current code just specifies zoning districts where the use is conditionally allowed and doesn't have the standard. After hearing a lot of testimony from members of the public that were interested in this topic, this was the language that staff settled on. I kind of give you the background, Commissioner Davidson. Staff was looking, I would say, for potentially a middle ground. Obviously prime farmland, it's all perspective, but prime farmland could potentially be a middle ground, being the best or the most precious farmland to protect. Obviously, there's lots of other types of farmland that are also very valuable. But this also gave us an opportunity to identify a resource that would make this very easy to distinguish based on USDA mapping. So this is where staff landed, and this is what's currently in the draft as a baseline.
So, Mr. Chairman, so then the definition, the next item, their definition, is relevant to this because it goes to what you're saying about what we would use as the basis of defining prime farmland, correct?
Yeah, Mr. Chairman, Commissioner Daly, that is one of the challenges that our planners face is being able to make a distinction. If it's unclear what qualifies as a, trigger that would prohibit or allow something. It makes it very difficult for staff to operate. So having a clear, decisive definition of what is and is not applicable is very, very key for us. So yeah, the Planning and Zoning Commission, I don't know if you were referring to their definitions. Moving to their recommendation, they went a little bit further, and they're recommending that definition, or that, I should say, standard that I read, be modified to read, solar facilities shall not be located, or I think there's a typo here. Solar facilities shall be strongly discouraged on irrigated prime farmland, farmland of statewide importance, and farmland of local importance. And then they do recommend that you adopt definitions for those two new types of farmland. The next two bullets are recommended definitions for farmland of statewide importance and local importance.
Mr. Chairman?
Yes, go ahead.
So the question, what you read was from Planning and Zoning, because they presented that here at our hearing, as I recall there, that.
Yeah, Mr. Chairman, Commissioner Daley, what I just read, which is on the screen, is from the Planning and Zoning Commission and their recommendation.
Right.
Mr. Chair,
Yeah.
did they give a minimum property size? Because staff has minimum 10 acres, correct?
Yeah, Mr. Chairman, Commissioner Davis, I don't believe they made a recommendation on the property size. I think they left it as proposed, unless I can scroll down here and see another recommendation. I think they left that to the standards as they were written and proposed by staff originally.
And so staff's proposal was solar facilities shall not be located on irrigated prime farmland. P&Z's recommendation was, I guess, similar, but they really expanded the definitions of farmland, or included more expansive definitions of farmland.
And I would add, Mr. Chairman, Commissioner Davison, that they, in their deliberations, they landed on it shall be strongly discouraged. So there is another distinction there.
And obviously that leaves it to the board's discretion, I would say. So would you say under staff's proposed language, solar farms on irrigated prime farmland would simply not be allowed, and under P&Z's definition, it's strongly discouraged, but the board could allow it?
Yeah, Mr. Chairman, Commissioner Davis, and typically we, as planners, we would shy away from, using that terminology, strongly discouraged, because it's just, we don't know quite what to do with it. But yeah, I guess ultimately it would leave it up to the decision makers to kind of make some kind of call.
Mr. Chairman?
Yes, go ahead.
I don't like the strongly, well, I guess, how would you, if you were trying to implement that, how would you do it? Strongly discourage? I think that would be, I like what's written here on the paper much better than the strongly discouraged, because this gives a little more parameters around, gives flexibility to you/us in terms of making the decision on terms of prime farmland, definition of prime farmland, because we can use Department of Agriculture Natural Resource Conservation Service definition. We can use statewide importance. We can use local importance as we establish both of those things. So I think this language here, not strongly discouraged, without that strongly discouraged in there, I would agree with basically the way it's written in those two, through three, I guess, the modify the add and the add, but take out the strongly discouraged portion.
And
That's on the screen here.
Are you looking at keeping the P&Z's definitions for farmland of statewide importance, farmland of local importance, and I think those are the two main definitions we're looking at?
Right, that's what I said. These two language, I don't have a problem with those two definitional things, but take out that strongly discouraged language. That would be my, because this gives us, I guess basically we can decide on keeping it the way it is, because we've made decisions both ways on the way it is right now, or we could more clearly define it, and I like the more clear definition. Again, without having that strongly discouraged, because that I think would give us and you more heartburn than we want in terms of make that decision. But
Do we need a definition for irrigated prime farmland? Because they didn't include that, or is that just self-evident?
Yeah, Mr. Chairman, I will add that I was handed a note that irrigated may be a challenging term for staff.
Well,
Prime farmland is definitely defined, but whether it's irrigated or not does add a challenge.
Mr. Chairman,
go ahead.
Natural Resource Conservation Service in their evaluation does evaluate irrigated land versus non-irrigated land versus like in the Midwest where they don't have irrigated agriculture. So they actually have they do that consideration. Not that we would have to use theirs, but it can be determined by their, so that would give us some framework for considering all of those things. Irrigated, non-irrigated, in arid land, which is the West in Idaho, versus Midwest. So they've tried to thread that needle in their analysis.
Good to know.
I believe that we're entering into an area that we don't have significant knowledge about. In determining what's prime farmland, determining what's prime farmland with statewide significance, I personally would rather have us develop a standard of conditional use permits with some detail of what we believe should be in a solar area. And because it's already limited by where they can be, has to be close to transmission lines. It has to be, we already know that. And so how are we gonna be determining what is prime farmland? I don't know how we do that.
Well, they did, in the P and Z language, they put their definition as farmland of statewide importance is land that, in addition to prime farmland, is of statewide importance for the production of food, feed, fiber, forage, oilseed crops, and/or raising livestock, and that is available for any one or more of such uses.
Well, you could put that on any piece of land. It's got a bunch of rocks on it, and it might have a few seeds that can be planted on it. You could say that's prime farmland. I don't know if that's an adequate description. I think that we'd be better off if we focused on descriptions of conditional use permits, the kinds of things that we would like to see in so the solar people would know exactly what they have to do. And, that could be a decommissioning plan, that could be all kinds of things that we think are important. Put that in there and let somebody else decide on whether it's prime farmland or whether it's farmland of statewide significance, because I actually think we've kind of missed that boat on prime farmland. I mean, there'd be a lot of places in Ada County that wouldn't have houses on it if we had that definition. Is that right?
Potentially, Mr. Chairman. Yeah.
Yeah. So I don't know that if we should single out solar from farmland, because that's Ada County. 50 years ago, Ada County was a big agriculture county. Now we're not. We're a bedroom community. And I don't know the prime farmland, how you define that is really troubling to me. Define prime farm, and you say, oh, if it plants stuff, right?
Well, my assumption is that the elected officials would have to have a reasonableness standard,
Well, if you have a reasonable standard, why don't we come up with conditional use permit standards? That's the same thing.
Mr. Chairman?
Yeah.
I think that if we have this in there, that does the very thing you're just talking about. It requires the applicant, whether it's an agricultural producer or somebody who wants to use agricultural land, to do exactly what you just described. They would have to say what is prime farmland. As you well know, because you grew up on a farm, if you have 160 acres, 160 acres are not prime farmland, and you know that as a producer, you know which is your most productive acres on that land. So this then requires the applicant to say, okay, here is and they could still do, whether it's 500 acres or 5,000 acres, they would then have to come in and say, oh, okay, here is my prime farmland based on this criteria, either a USDA standard or my production reports. I produce this much wheat on these acres or whatever. They could use any standard they wanted to prove which part is prime farmland, and they could even use, on 160 acres, they could take 30 acres and put a solar farm in conjunction with somebody else's. This doesn't prohibit them from
Well,
doing
they
that.
could propose that, but then what's to say that a future board would say, no, we don't go along, we don't agree, we think it's all prime farmland?
Well, they could say that anyway, even if it isn't in the code.
Exactly.
They could say, no, we're not going to do it. Because
right.
just like we did,
Like we already can do currently.
precisely, that's why I said
We
we're,
don't need this extra language, I don't think. We've already done that. We've already said we don't think that solar farm that bordered Canyon County and Ada County, we already said, no, we don't want to do it there. We don't think it's appropriate for that area. We could still do that without this language.
I guess my concern is leading the solar companies down, the primrose path and then yanking the carpet right at the end,
That's why I'm suggesting we give a detailed conditional use permit. Isn't that kind of what we talked about one time?
Yeah, Mr. Chairman, essentially, the current approach, let applicants propose something, and then they go through the detailed process, and it's determined through the public hearing process whether.
But I don't think we have a detailed enough.
Certainly, yeah, Mr. Chairman, we are
Conditional use
proposing
permit now.
additional
I would be.
additional
proposing-
standards.
I would
The
be
Planning and Zoning
proposing we
Commission
have
has additional standards for sure.
And
I
very
can-
tough standards that they would know, and that wouldn't be leading anybody down the primrose path. They could see if we fit this, this works, then we can put a plan in. If it doesn't, we can't. We could still turn it down if we didn't like it.
but Mr. Chairman, I don't see the difference between putting it here and doing exactly what you just said, because we're doing the same thing. We're putting a box around it either way. It's just a matter of where and how we put the box around it. And putting it in the code is
Go
one
ahead.
way. It's one way to do it.
I mean, to me, the problem we're trying to fix is, it's twofold. So if we go back to our previous decision on the solar farm outside of CUNA, those applicants were willing to have a decommissioning plan. They were willing to offer any plan just to get it approved. But the issue was the neighbors didn't want it in their neighborhood on their farmland where they had to look at it. So all the conditional use and plans that any company wants to impose on themselves, it still doesn't get to the issue of, well, the neighbors are going to rebel because they don't want it in their neighborhood.
So how are you going to prevent that with just defining farmland?
You won't.
You're not going to prevent that by just defining, because I'm saying that it is difficult to identify prime farm ground of statewide significance. That's almost an impossible task, I think, and it's very subjective.
It is very subjective, Mr. Chairman, but as you well know, as a farmer, they do it every year when they plant.
Oh,
They say, this is my prime farmland. This is where my most productive acres are. This is where I'm going to plant. They even have GPS now that applies their fertilizer, applies their seed based on the productivity and the water availability.
Oh, I know.
On a specific square feet.
Because I did grow up on a potato farm, as you know, but we also grew grain. And there was a point in time when the USDA was paying people to not produce grain. And so what the farmers would do is, well, I can't produce any grain there anyway, and that was their farmland that they were turning over to not produce grain. You know that.
Yep.
And and you're right. But they didn't say we couldn't produce grain on it. They just wanted to get paid for it by the government.
And that's exactly why USDA did what they did. Analyzed every acre of land, and they took them 10 years to do it, and they have the productive value of every acre of farmland in the United States now. And that's why they did it, because people were doing
Just what
exactly
I'm telling you.
what you said.
I just know that was happening. I
So
know
whether
that
it's
was happening.
whether it's CRP acres or
Now, we produced a lot of potatoes, so that we had to produce the potatoes to actually get paid.
that's right, because it wasn't a
It
commodity.
wasn't a commodity that the government was subsidizing. Yeah.
I'm just wondering if adding that language, though, just kind of puts the companies on notice to be a little more careful and not jump into potential piece of land and just kind of hope that it works out. You know, they'd be a little more careful to choose the land.
Or even put together a package, like the 1,400 acres that we were talking about. Or if they have 5,000 acres, they go and say, okay, if it's 5 producers or 1 producer, they go and say, okay, where could we put our solar farm to make it workable for us on your 5,000 acres? And they would do it in relation to the productive value of the farmland. And it would be an advantage to the farmer as well as to the company, because they then would have, the farmer would have additional land income off of his land, and it would be delineated, and he would know right in advance before they started the project, okay, I have this many productive acres, this many acres that I can actually give up for a solar farm, and still add to my bottom line. It's just like where they plant their crops to. I guess I think it helps both sides, not hinders.
Didn't we just add a section about private property rights into our code? And aren't we impeding on some private property rights? Say I've got some prime farmland, but I'm tired of farming. I just want to plant some solar panels. I couldn't do it under this.
Well, there are lots of things where, if that's the case, we throw the whole zoning code out, because we're doing that
Well, no.
in lots. Well, as you said,
Yeah.
houses. I mean,
Well, we've already done that. That's my point.
and we're still doing it.
We're still doing
And
it.
this doesn't change that.
We'll, no, we'll still be planting houses instead of solar panels. And I think we should be really more strict on our solar farms than what we have been. I think we should. But I just don't think that by making a statement like that no solar farms can be at all anywhere on prime farmland of statewide significance. I don't know how you define that. You say the farmer will define it.
He defines it every year when he plants.
Exactly, but that's not the point. We're asking Richard here to define it when somebody comes in.
We're forcing them to define it when they come in with the application.
Also, it says strongly discouraged, not banned, so I guess it's, you know.
No, I don't.
He
agree
didn't
with
want
that.
the strong.
You
I
don't,
agree.
you want
He wants
just
flat
outright,
out.
yeah.
It's not just.
Just say prime farmland and then have a definition, workable definition for prime farmland. That's all I'm asking.
I mean, I wish we
That's
had
all
a better way to encourage the development out in the desert where they don't want to go, but where there'd be very little objection, like the one that we
Well, we've approved several
Approved,
of them
yeah.
out south town where they.
Well, Mr. Chairman, Commissioners, that's a good segue into the final location recommendation, which you recall was from the Fish and Game, recommending that you add rangeland and wildlife components to the location restrictions as well. So that was the final recommendation that I didn't get a chance to share for location.
Well, they want to add range. Well, that takes away a lot of prime farmland.
they want to disallow on rangeland.
Yeah, Mr. Chairman, let me see if I can find find the language here.
Well, if we took those out with Fish and Game, then we pretty much eliminated solar panels in Ada County.
No, not on all that desert land out there.
You mean on BLM?
Yeah.
Yeah, so Mr. Chairman, if you recall, Mr. Letson covered this in his staff presentation, but the Idaho Fish and Game Department wanted to add to the end of the Planning and Zoning Commission their recommended change. They wanted to add rangeland and fish and wildlife habitat of statewide or local importance to the strongly discouraged list.
Now, that's for solar panels. What about windmills?
No mention of windmills that I know of.
This
We
is
don't have anything in the code about windmills, do we?
No.
Mr. Chairman, I think Commissioner Davison, we do. I don't know that we've seen a lot
Yeah,
of
but
them
we
based on
have
the
a general-
resources that we don't have, but
we have a general applicable one, right? That there's a catch-all.
yeah. So yeah, Mr. Chairman, as a staff person listening, Commissioner Commissioner Daly mentioned 5,000 acres, a farmer determining where solar panels would go. If that 5,000 acres is all designated as one of these classifications, the question we would have is, what flexibility would that standard give us to let them still establish the use even though it says it's prohibited? That would be a follow-up, I guess, from a staff.
Well, I guess, I don't think even in the Midwest, there's a 5,000 acre parcel that's all prime farmland, even under this criteria that we're talking about here. It's not all prime farmland. There's no block of land that's all prime farmland. There just isn't. It's varying degrees of value for productivity, but it's not all prime, which is the top tier.
Right. And staff did do research. Our Planning and Zoning Commission did have a recommendation to remove the term irrigated. They recognize based on testimony that there's prime farmland that may not be currently being irrigated, that's also still prime farmland. So that term irrigated was not part of their recommendation.
I wouldn't have a problem removing that, but you, as I said before, USDA definition does include that. I mean, if it's not irrigated, it has a different productive value than if it is irrigated. And that's for like CRP. It was one of the ag programs. CRP land that's irrigated has a different productive value than non-irrigated, just desert land that's whatever moisture it gets. So I mean, I think the USDA has done pretty extensive work on that, and they have tiers as well that they establish, and it's acre by acre. It's not 160 acre parcels. It's acre by acre.
Yeah, Mr. Chairman, Commissioner Daly, I guess if you do vote to include some of these definitions, I think we would have to definitely take a look at the data that we have and make sure we've got more, the most granular information that we can get, for sure.
Mr. Chairman?
Go ahead.
You don't have to use USDA. We can use a number of other, based on the language of the way I read it anyway. Maybe you, as a staff, would clarify that, but using resources provided, I mean, USDA is one of those resources provided, so we could use any number of resources to make that evaluation, we, the staff, and/or the commissioners. And that's the way I read that, unless you read that language differently.
No, Mr. Chairman. Commissioner Daly.
Mr. Chair.
Yes.
I guess I should point out, we're spending a lot of time talking about farmland, but really when it comes down to it, it's any neighborhood doesn't want this to affect their neighborhood, whether it's prime farmland or not. So, I mean, if you have a neighborhood out in the desert and, the solar company wants to build a solar farm next to them, I guess, are they just out of luck? They don't have the same protection that farming communities have?
Yeah, Mr. Chairman, I don't know if that's a question for me or if that's the.
Rhetorical question, I guess. But just to point out that, I mean, really, what it comes down to is we want solar power, but people don't want it to affect their neighborhoods, whether they're farmers or not. And so that's what we have to keep in mind. We do want to protect farmland, but we're overall trying to protect quality of life for the residents. This makes it a very difficult task here we have.
Well, it's, our current plan does that. We turned down a project because we had a lot of neighbors didn't like it, and we didn't think it fit in the neighborhood ourselves. And we can do that under the current situation without defining prime irrigated farmland.
Irrigated or non-irrigated?
Yeah, so, anyway, that's my position, but go ahead if you wanna.
I've stated my position.
Yeah,
too,
you've stated your
If it's
position.
back to you,
You wanna, no, it's not me, it's,
that's why I was.
it's up to Ryan, if he wants to include the planning and zoning recommendation, is that what you're going with, is planning and zoning recommendation?
Yes, absent the strongly discouraged.
Oh, you just wanna say just discouraged, period.
No, I just want to say, shall not be located on irrigated prime farmland.
Well, that's stronger than strongly discouraged. Right?
Well, how you define strongly discouraged, and
Yeah. Okay, well, so Ryan, once again, you're holding the balance.
Well, I feel like whatever we come up with, we can still continue to research and get feedback from the industry and landowners and obviously make changes as necessary.
Oh, we can always do that. We can always change something.
yeah, this will not be in concrete no matter what we do.
This is not written in stone. Right, Richard?
That's correct, Mr. Chairman. Yeah, if you find that there's another direction you need to head in a couple months,
I mean, I do want to give the solar companies some certainty about what they can do and how they can do it. I don't know.
This gives them certainty, they just can't do it.
Well, it's probably
Yes,
better
they
than.
can. They've done the way I described it. They've already done it over in Bingham County. They've taken a section,
Okay.
and they approved it on a piece of property, and there's still farming part of it, and there's a solar farm on part of it. So this would do that, but we could. I guess I said right at the beginning, we can leave it like it is and do like you're talking about, or we can do the extreme to one side or the other, or take I think this is more of a middle ground, but you think it's extreme, so.
Well,
I may want to start with one extreme or the other as just to give some certainty and then kind of work towards amending it as the conditions dictate. But
so what you'd be arguing for then is to just table it till later and do more work on it.
no, I think we could, well, I think we could make a decision tonight and adopt something, but continue to work on it, as we get more information from the solar companies, as we see how this is going to work out. I mean, if it ends up being an effective ban, then I think we would want to revisit it. But I mean, I felt in the old hearing that we went through, I felt a lot of support for this protection of farmland in Ada County, even though obviously we're an urban county, but there is still that desire to sort of hang on to
Left.
what we have left, which is dwindling. So I mean, I would probably go your direction at this point, I think, and then just continue to work with the companies and revisit this if needed.
Well, you don't want strongly discouraged either, right?
Well, I would even be willing to accept that, although I think it's going to be difficult for staff to interpret.
Well, I agree with that, because a strongly discouraged statement is rather subjective.
And your language was what?
Just take that out and leave everything else in there that they have. That would be my, just take out the strongly discouraged, leave everything, all three of those, then the language the way it is.
Now, would we be keeping in all the other CUP requirements we have that you're wanting to put in it?
It kind of looked like a lot of the additional recommendations they had were basically the same as what staff was recommending with
Yeah, well, that's
long-term bonding, standards for setbacks, landscaping, decommissioning plans. Was there any other standards that they had put in there that staff hadn't really already looked at?
yeah, Mr. Chairman, Commissioner Davison, the remainder of the list essentially somewhat deviate from what staff has. I can pull up what's in the code, what's proposed as part of the staff proposal, if you'd like to see that real quick.
Obviously, some of the concerns that we heard were, well, what if a company goes bankrupt and just abandons the project? And so who's responsible for decommissioning it, get rid of the panels? Do they go in the landfill? And so the idea was floated of, making sure they have a decommissioning plan and having or posting a bond for cleanup, I guess, if the company just abandoned it.
Yeah, Mr. Chairman, Commissioners, on the screen, I know it's going to be difficult to see, but the additional requirements that are in smaller lettering are what is included in the current draft. So there was a requirement for a decommissioning plan, but the Planning and Zoning Commission had the recommendation to go further to require bonding to kind of back up the operation and the decommissioning in the long term, in the long run. So that was a little bit of a different deviation. Staff is also recommending a fire protection plan, emergency response plan, and vegetative management plan. That was the kind of the base additional requirements there for the what's proposed in the code. So the recommendations, there's a few, I guess, some variation here for the Planning and Zoning Commission is recommending. So they've got the long-term bonding. They're recommending incorporating standards for increased setbacks, additional standards for landscaping and screening, wildlife corridors, fire suppression systems and training, standards for review and mitigation of noise, vibration, signal interference, and then lastly, maybe not lastly, but incorporate standard for maximum lot coverage and increase the required distance for public notices. Those were the additional standards that they proposed be added to what staff has already.
I mean, some I would agree with, others I don't know. I mean, standards for review and mitigation of noise, vibrations, and signal interference. Well, we never had any evidence that these produce much noise at all. So I don't know if that would be necessary. The bonding issue, that's certainly subject to debate. But, I mean, all the other, like landscaping, screening, wouldn't that kind of already be covered in our code? Well, only if it's conditional use.
Yeah, Mr. Chairman, these facilities require conditional use, and yes, we have some standards. Typically, we see applicants request modifications due to lack of any type of water out, sometimes in the desert scenarios where they're unable to sustain the landscapings. So there are some standards that are applicable. I think the Planning and Zoning Commission was looking for more.
And that would include the issue of battery fires, I guess, which I still haven't really heard, what's the best plan to deal with battery fires, potential battery fires.
Yeah, so Mr. Chairman and Commissioners, I don't know if you want to take these up one by one or what would be best to walk you through these.
Mr. Chairman, question?
Go ahead.
So these are proposals from Planning and Zoning
Yeah, what's on the screen are the recommendations from our Planning and Zoning Commission.
to put in the code, not in not as a policy recommendations. But
To add to the
To add.
the use standards for a
the use
solar farm, yep.
standards, okay.
So would you like a final answer on the main language, and then we move on to these?
If you're ready, I'm all for it.
I'll support Commissioner Daley's proposal.
Mr. Chairman, I don't know that it would be beneficial, but from your point of view, but even if we qualified, because USDA has tiers of, so it'd be tier 1 and 2, or some of the, put in there some tiers in the National Resource Conservation Service, because I think this, since it's not mandating using their qualifications, I don't know that we need to go there, but if that would be helpful to you to put in something that would qualify that in terms of their analysis.
Well, I think that whole thing is rather subjective anyway.
It very much is, yes.
And so I just don't know how it's going. But hey, two of you are going for it, so go ahead.
Okay.
And Mr. Chairman, Commissioners, as you think about that, you have that added complication of the Fish and Game recommendation as well.
I mean, so their concerns are the impact on wildlife.
Yeah, Mr. Chairman, they're concerned about rangeland and fish and wildlife habitat of state and local importance.
Well, hearkening back to previous testimony, I don't recall hearing any evidence that these had any major impact on animal population, but I could be wrong. I just don't recall hearing any serious testimony that it's a big issue to wildlife.
Mr. Chairman?
Yeah.
I would ask the same question because we asked for their comments and they didn't have any comments in the solar projects that we approved and or disapproved. They had no comments in terms of Fish and Wildlife, so I don't know why that would be a necessary requirement either.
Yeah, Mr. Chairman, Commissioner Daly, they have had comments on some of the past applications. Depends on the area. The one east of Micron specifically, they were concerned about wildlife corridors there. So they have been participating in some of the applications that we've seen come through. I will point out that the Planning and Zoning Commission did have one recommendation that we require a standard that enables or requires applicants to establish wildlife corridors through the project. So the P&Z was thinking about that topic, but so they have, Fish and Game has participated in some of the past projects.
How many wildlife corridors are there on private property?
Mr. Chairman, I don't think I can answer your question. There are definitely established wildlife areas, especially in our comprehensive plan and in some of the Boise Front range there, for sure. But yeah, as far as actual designated corridors, I'd have to defer to Fish and Game.
Well, I don't know. I don't know that it's applicable to our zoning code. Because wildlife corridors, we already mentioned it in some areas, correct? So,
And we've, Mr. Chairman?
yeah, go ahead.
And we've actually considered it in some of those as well.
That's correct. Yeah, Mr. Chairman, Mr. Daly, yeah, the Fish and Game is working with one of our associate planners and a developer right now to address accommodating wildlife through a project and what that would look like. So yeah, we are relying on them to kind of help with that aspect of the approval because it's a requirement.
Mr. Chairman?
Yeah.
So not having it in the code would not restrict us from doing what we're already doing.
Yeah, Mr. Chairman, yeah, we'd still have the conditional use process for all these facilities. Fish and Game would still be notified. They could speak up when they see something that's really of concern, and then we could address it through a condition of approval.
Thank you.
Mr. Chair?
Yeah.
So where would agrovoltaics come in on this, either requiring or allowing?
Yeah, Mr. Chairman, I don't think we mentioned agrovoltaics in the code that I ran across. So I suppose a developer could propose something.
But
part of their
there's no
proposal?
requirements.
Yeah, there's no requirement for agrovoltaics that I was able to see.
Okay. So what else we need?
Yeah, just looking at all these others.
So yeah, I did not want to derail your decision on location. I guess you could set aside Fish and Game and focus on your concept for whether it be appropriate to prohibit on certain types of farmland or not.
Well, I think these two have agreed with the planning and zoning's recommendations with taking out that one sentence, correct?
2 words.
2 words.
But I could keep the 2 words in there too if I. So what do you like strongly encouraged or not? Strongly discouraged, I should say, or not?
I'd say no.
Okay.
So, Mr. Chairman, Commissioners, I'm hearing you would follow, or I guess you would use the Planning and Zoning Commission's recommendation, but say solar facilities shall not be located on irrigated prime farmland, farmland of statewide importance, and farmland of local importance, with one follow-up,
With the definition.
with the definitions added.
Definitions.
And the follow-up is the Planning and Zoning Commission, again, focus on the word irrigated. Do you want to include the word irrigated or remove that and just focus on prime farmland?
It isn't in this language that's on the.
Oh, interesting,
sheet,
okay.
right? irrigated is not here.
Perhaps, Mr. Chairman, if it'd be okay if Commissioner Daly, if you read what it is that you're proposing?
Yeah, it's that the recommendations list that you had. That
Does not include the term irrigation.
does not include.
Does not include, okay, so it's the correct recommendation. I apologize. So you're recommending solar facilities shall not be located on prime farmland, farmland of statewide importance, and farmland of local importance with the inclusion of the two definitions?
Right.
And that's the recommendation that you'd like us to proceed with?
Yes.
Okay. Okay, I guess that leads us to the final recommendations from the Planning and Zoning Commission. The first is they're recommending that you require them to serve as a recommending body to you about the approval of future solar facilities. Essentially, they would like to see these applications treated like a preliminary plat where the application comes to them, they consider the public testimony and make a recommendation, and the board makes a final decision. As currently written, this would be a conditional use in a master site plan. There's no longer a variance component, which is why it usually ended up coming to you for a final decision. So as the zoning ordinance is proposed, it would go to them and they would make a final decision, and you would only see it if it was appealed. They're recommending that it still come to you, that they're just a recommending body. So would you like to incorporate this into the code?
Mr. Chair?
Yeah.
So you said, under the existing process, they're able to approve it, but then if they disapprove it, it could be appealed to the board, and this would just be a recommendation to the board.
Yeah, Mr. Chairman, Commissioner Davison, under the proposed zoning ordinance, it would be a conditional use master site plan. They would make essentially a final decision, and it would only come to you upon appeal.
That's what I thought they were recommending that there won't be, that they only be advisory.
That's correct, Mr. Chairman.
That is their
Yeah.
recommendation.
Okay.
All these recommendations, if I recollect, it was all on a 6-0 vote of the P&Z committee.
I believe so, Mr. Chairman, yeah, after much deliberation.
So they don't want to be a final arbiter. They want us to do it.
Mr. Chairman, I think that's why they're there, is to do the, I don't,
Well, they're a recommending body anyway.
right.
I'm saying, and even if,
So this
even
is-
if we didn't adopt this, anybody could appeal whatever their decision was anyway. correct?
Exactly.
So it's not, it's a distinction without much of a difference, but I think if that's what they want to say, I'd go along with it, fine.
Have them all come to us.
Well, they will anyway.
Well, maybe not, but
Well, if there's not controversial, then it wouldn't be a big deal, but the ones that, if there's two sides and one side doesn't win, then they typically will appeal it. And that's when we look at it anyway, but because we don't want to get into the position like the city of Boise was in, where their decisions were final, and then their decision went to the Supreme Court, and they said, you didn't follow your own recommendation, because they appealed it and you overturned them.
yes, that's why I think we should
Yeah.
take this out and not to put this in, because then I think that's our strongest position.
Well, we're saying that they say they just want to make everything recommending to us, right? No final decision.
That's what this language would do, correct?
Mr. Chairman, this is specific to future solar.
To solar farms, yes. Just
There's
so-
other conditional use and master site plan type applications that they would be the ultimate deciding body unless appealed.
That's why I think
Just
we,
these application types that they've made a recommendation.
Mr. Chairman, that's why I think we need to make it consistent with all the other.
I do too, that's fine.
So not adopt this language then.
Okay, so I'm hearing not incorporate this, okay.
I mean, that would take care of certainly some non-controversial ones. Don't need to come to us. But if they do, we just have to heed the Supreme Court decision, and we have to reverse or uphold on clearly defined criteria. We can't just make up criteria. We have to take,
Well, no, we don't want to change that. We want to change, if we decide to go against what the Planning and Zoning Commission is, we just do it.
Right.
We don't.
Because they're advisory.
That was the problem,
Because
because they're
they're
advisory
advisory.
only. That was the problem that the city of Boise got into, is that is how theirs read. Theirs said that you had to object to a process rather than what their actual decision was. And we don't want to change that.
No, we want
We
we
want-
want to leave it just like it is with everything else.
Like it is, that if anybody appeals, then we have, they have the right to get it overturned.
Okay. And Mr. Chairman, Commissioners, the next recommendation from P and Z is to incorporate standards for long-term bonding for the safe operation decommissioning of solar facilities. Is that something you'd like us to incorporate into the use standards?
Mr. Chairman? I think we need to have some assurity that there's long-term money available so that we don't get 30 years from now, I won't be here, but the county is then left holding the bag to try to decommission 250,000 solar panels and all that's required there. So I don't know that if bonding is the correct term, but some mechanism, and I don't know if there's
Okay.
another term that would be more broader, than
Well,
bonding.
And bonding is an actual market. We don't even know if there's a market for this kind of bonding. We really don't.
So a financial surety?
Financial assurance.
something like that.
Find some sort of financial assurance. We do that with our planned unit developments. We ask them to make us a financial plan. And then we sign off on the financial plan. Now, we don't know if they'll actually be able to fulfill it or not, but,
Mr. Chair.
yeah.
I mean, I like the idea. I just wouldn't want it to make an entire project cost prohibitive. So I guess, I mean, are we talking about, we would require them to deposit the total amount that it would cost to decommission and scrap the solar panels?
Some kind of financial security,
Well,
whether,
that might be if there were no bonding capabilities. See, I don't know what kind of bonding capabilities, because bonding companies, they're gonna wanna, that's how they would guarantee that they would never pay a bond, is to make them pay it up front. That would be their bond.
it would be kind of like what we did with the soccer. They have to put some upfront commitment that,
Well, they did, but that wasn't bonding.
right, that's what I mean. That's all I mean. I think we need to have something, but bonding is not necessarily the only vehicle that we should.
Well, and that's something, how are you going to determine that? How are you gonna determine what the decommissioning cost is 30 years down the road?
Yeah, Mr. Chairman, Commissioner, I think this is something that the industry can do. Would you like to treat it like we did with the county engineer, where we can come with some more information that you can consider?
Yeah,
Yeah, sure.
yes.
Okay.
Because if this is not realistic, we shouldn't be putting it in our code either.
Well, that's what I don't know. See, I don't know if there's even a bonding market. You can buy bonds for a lot of things, but I don't know if you can buy bond for this.
We'll come back with some more info on that one, Mr. Chairman. The next recommendation is to incorporate standards for increased setbacks to property lines and existing residences. The Planning and Zoning Commission didn't, to my knowledge, provide any specifics as to what those would be. The current standard, these are allowed in the rural zones, which typically have a 25-foot to 30-foot setback minimum. They were thinking of a greater setback to existing residences and from exterior property lines. I want to say they threw out 300 feet to residences. So is this something you would like us to look at as adding to the use standards to increase those setbacks?
Mr. Chairman,
Go ahead.
that's what I was going to ask you. What would be? Do we have any kind of data that would substantiate, like in other locations, like in other states, or whatever kind of things that have had? Because we don't have a lot of experience in this in terms of setbacks and things, but I think it's useful to consider that. But I don't know, because they said more specific or increase the setbacks. I don't know how to set that standard, if that's what they're asking for, or if we could just put it as general language take into consider a review of setbacks or something like that, so it wouldn't be fixed amounts that may be unrealistic. I mean, that's my feeling on it. I mean, I think it's important for us to consider as we move through that process, but I don't want to put something on there that's unrealistic for anybody.
So maybe, Mr. Chairman, Commissioner Day, I'm hearing a kind of an encouraged scenario, encouraged standard where developers are encouraged to increase the distance between existing residences and property lines with
And,
solar panels and electric substations and those type of things.
Excuse me, Mr. Chairman?
Yeah, go ahead.
And that could be different. In other words, if some of the ones we've approved out in the middle of the desert, it's on private property, it's out in the middle of the desert, it wouldn't be the same as if it's close to people and that sort of thing. So I guess that's why I wouldn't want to fix an amount that would be unreasonable for the circumstance either.
Okay.
Okay, we will work on some language
All right.
that encourages additional, or I guess greater setbacks into the spirit of this recommendation. Next, I've highlighted two here, but the top highlighted section incorporates standards for landscaping and screening requirements. As I mentioned earlier to Commissioner Davison, we do have some standards in the code. And again, a lot of the requests are including a request to modify or to have alternatives based on either the rural nature, lack of water, different things like that, but we do have some standards.
Mr. Chairman?
Yeah.
I think we already have, I don't think it needs to be exclusive to solar because we already have it in the code that applies to everybody, so.
I think
I don't
so.
think we need that either.
Yep, I agree.
I agree.
All right, thank you, Mr. Chairman. Commissioners, up next is incorporating standards for establishing wildlife corridors through projects where applicable. Would you like to add that to the use standards?
Didn't you say we already have some wildlife corridors anyway?
Yeah, Mr. Chairman, I think this would be a site-specific scenario where,
Could we say current corridors?
and again, I think they may be something that could be project-specific that aren't known, that when somebody evaluates the property, Fish and Game, that they're aware of either some kind of population. I'm kind of speaking off the cuff here, but we can put it in whatever language you would just deem appropriate.
Well, yeah, I think that's pretty subjective there. We don't know.
Again, I think we have a process, back to what we were talking about before, that generally applies to them, and I don't think we need to uniquely apply it, have something in the code for solar in that regard.
I agree.
All right. Okay, four more, Mr. Chairman, Commissioners.
Okay.
I think. So up next, Planning and Zoning Commission recommends incorporating more specific standards regarding fire suppression and training of local first responders. Again, as I mentioned, the current requirement is just for a fire protection plan that talks about fire protection measures and describes fire suppression methods. And the P&Z recommendation beyond that was getting more specific in the standards. I don't know what those standards would be, but that's their recommendation.
Well, I think what we already have is sufficient, because how are we gonna require more training for first responders?
Well, yeah, Mr. Chairman, I would agree with you, and the proposal that we have there, that you just read, I think is the fire protection plan provides for fire protection, and it goes, there's, I think that's sufficient.
That's sufficient.
I don't think we need to add
You
any.
agree?
Well, from what we've heard from our local fire departments, this issue is very much on their minds, that they're, coming up with ways to deal with battery fires. We just talked about some special foam cannons that we authorize. So I don't think we need to tell the fire departments that this is an issue that they need to prepare for. I am curious about, industry standards for these batteries, if there's some mechanism that would have to be built to contain the battery fire that would be an expense to the company, some technology that hasn't been invented yet. Should we leave it open that we could require something like that?
Mr. Chairman.
Yeah, go ahead.
I agree. I don't think this is necessary for the reasons you've talked about, but also these are evolving standards, and if we start trying to define them now in our code, I think we would maybe be going places that we
I agree.
may not want to go later.
So what you currently have in there is fine.
Exactly.
Okay, Mr. Chairman. thank
In
you.
the staff report.
Yeah.
Yes, in the staff report.
All right, up next, incorporating mitigation standards, review and mitigation of noise, vibrations, and signal interference.
There again, I think this is
I think that's a little
beyond,
overreach.
beyond.
I've never heard of a noise complaint from a solar farm, but there may be, but I haven't ever heard of it.
I did ask about that during previous testimony, and again, there's no evidence presented that it's anything more than a gentle mechanical noise.
I'm hearing, Mr. Chairman, Commissioners, no?
Yep.
No,
Okay.
yeah, take that.
No,
No.
second to last one.
You're correct.
All right. Second to last one is a recommendation to incorporate a standard for a maximum lot coverage. And this is one, again, essentially all the solar farms that have been approved in the past requested a variance from lot coverage and received approval of the variance. So this lot coverage standard was specifically removed in the recommended ordinance by staff when it comes to being applicable to a solar farm. And the Planning and Zoning Commission would like to add one, is recommending that you add one back into the standards.
Mr. Chairman, I think it goes back to what I was talking about, the boundaries, same thing. If we started doing that here for these, it may not be applicable to everywhere, and we would have to get variances for that. So I don't think we should do this.
I agree.
Chair.
Yeah.
I mean, if we have setbacks imposed in the other section, that kind of addresses the issue, doesn't it? I mean, if the goal is to have a buffer between, the next house and the solar panels, I think the setbacks would do that, because obviously they need as much land as possible if they're going to make the solar farm profitable. So, and I don't know, what was the standard for maximum lot coverage? They just said leave it to us, or?
So, Mr. Chairman, Commissioner Davidson, in the original code, the old code, it was 5%. In the rural districts, it's been increased in the proposed new code to 10. So the code does have a maximum coverage for all of the uses. This particular use is exempt. I heard 2 no's.
3 no.
Okay. All right, I think there's one more. Yes. So they were recommending that you require an increase to the required distance for public notice. So currently in, I guess, both versions of the code, the old one and the new proposed code, staff has a half-mile radius requirement for this type of use. A centralized power facility requires a half mile, one of our largest that we have. Would you like to increase the notice requirement?
Mr. Chairman?
Yeah.
So that, you just answered part of that. So what is it? What is the standard other than you said 50 is how much did you say is the proposal for this? Staff recommendation for the distance?
The current distance is 2,640 feet from the exterior boundary of the site.
Okay.
For notice. It's one of our largest half-mile.
Mr. Chair?
Yes.
I mean, I would support increasing it. I recall from the testimony we heard previously that was an issue, and it's because, these are going to be in rural areas with large parcels, and so, half a mile radius could just, might end up encompassing a few, 40-acre parcels, and then the people on the other side of those get angry that they weren't notified. So I suspect, increasing it won't add to our cost that much because, again, they're going to be in rural areas, and so there's probably going to be mostly farmhouses that need to be notified. So it's not going to be that many extra notifications, most likely. But I think that was a complaint we did get at the previous hearing.
Well, it should be noted that it's not our cost, because the project, they do the notifications.
Yeah, Mr. Chairman, Commissioners, we do some notifications, but obviously the applicant would be paying an application fee, which would cover
Right.
those costs.
So what's the proposal?
So what? They want us to pick the distance then, not them.
I
So,
don't think they specified it. Oh, they were 2 miles, okay.
so they recommend, that's what I was just going to ask, if they recommended something.
So it sounds like 2 miles. So would you like to add a 2 mile,
What are we requiring right now?
half mile?
Half a mile.
I'd be okay with 2 miles.
Just trying to think what that would be in terms of,
That's a long
that's,
stretch. It's a lot of notification.
yeah, I would be more realistic, I think, would be a mile. That would be doubling what it is now. And that goes to the neck. If you look at the grid, that goes, because like you said, if it's a half a mile, it's between the mile markers. So you might have a neighbor's house that would be, their farm would be there, but they wouldn't be in the half mile. So I would say a mile would be more realistic. If we're going to increase it.
Oh, I'd agree with that one.
2 for a mile? Sold, okay. Mr. Chairman, Commissioners, I believe we have exhausted all the known recommendations that were put forth by our Planning and Zoning Commission, as well as staff. Do you have any other direction or recommendations for staff to take into consideration as we prepare the final document to bring back to you? We will request some additional time to make these changes and do the research to bring it back to you. Probably need about three weeks.
Yes. And we'll work on that 10-mile overlay.
That's correct.
Yeah. Okay.
Is that realistically enough time?
With the 10-mile overlay, I'd probably go an additional week, Mr. Chairman, Commissioners.
So you'd want the first,
I would say, Mr. Chairman, the day after Columbus Day, on the 14th, if there's an open business meeting that we could come to you during.
As long as that gives staff enough time, because we want to make sure that you have enough
makes
time.
Take all the time you need.
that'd be fine. So we table it till the 14th.
Well, were there a couple items that you were going to get more information and bring it back to us to clarify?
Yeah.
They have some work to do. That's
Yeah,
why.
they have some work
That's
to
why I was asking if that's enough
And
time.
we can arrange those times.
Yeah, Mr. Chairman, Commissioners, if we get to the 14th and we're still struggling, we'll ask for some more time.
All right.
And I just want to check with the clerk that the 14th is
Yeah.
October 14th.
Yeah.
Okay, there's an open business meeting on that day.
Business meeting.
Yeah, it's fine. That'd be fine.
Yeah, Mr. Chairman, that is the day after Columbus Day, which I don't think, it seems like we always postpone the open business meeting.
No,
So,
if there's a holiday on a Monday, we just delay it till 10 o'clock.
Not 9 o'clock till 10 o'clock, yeah.
Yes, we still have the meeting, but we do it on at 10 o'clock till 9. Okay. The motion is to table till the 14th, correct? Okay, I would accept the motion.
Mr. Chair, I move to table project number 202402581-ZOA to October 14th, 2025, to allow staff to incorporate the revisions recommended by the board. And is that it? I think that's it.
That's it.
The sufficient motion, correct? That gives you enough direction?
that's correct.
I second the motion.
Okay, you've heard the motion. Is there any further discussion? I think that's, hopefully, you'll let us know if you need more time for that, and as we go along, we can get more information. Okay, so all in favor, say aye. Aye?
Aye.
Motion carries. Do we have any other business that we need to take up? Okay, so, we'll be adjourned. Thank you.